Someone in line for a question. So if you guys have questions, we're going to have you come up to the mic right here. But Barry Gold, you have a question?
You. Barry Gold, AARP. We've been talking about durable medical power of attorneys and how important they are, but I'd like someone to clarify. It's my understanding that if you call 911 and an ambulance or emergency medical technicians come and treat you, even if you show them this, it's not good, that there's a special form that emergency medical technicians have that they do that. Now, I don't know if they change that or not, but can somebody talk about that a little bit, that if you call 911 and they come, there's something special that you have to have for EMTs. And you're all looking at me like you have no idea.
All right, well.
Unless you're speaking of like a do not resuscitate order, I don't know that EMTs can honor that. That might have to wait for them to be at the hospital.
That's kind of what my understanding
is.
So if this says, if you have kind of a do not do anything to me, if the EMTs come, they start CPR, is that correct?
I believe so, but then it is quickly discontinued once it's proven up at the hospital. That's my understanding. Anybody else know better?
The reason why I ask, I know that in the state of Arizona, which is where I came from beforehand, there was a special form that was just for emergency medical technicians. But if you're telling me that doesn't exist here.
Yeah, I've never, and I'm not a medical provider, but I've never heard of that or seen it. And in talking to some groups that I've gone to talk to, small groups where it's very interactive, people have said, well, I don't want to fill out a DNR. What if I'm in a car accident? That means they won't do anything. I don't know this for a fact, but you know, it seems like it's get you to the hospital. These advanced directives are for conditions once you've been, if you survive, whatever the situation is, for your treatment or non-treatment. But I'm not a medical provider on that, but I've never heard of it, the EMTs in Nevada.
Would you, Carol? Well, and it's my understanding too with the DNR that only a doctor can give you that we as attorneys can't craft DNRs. I don't believe so, not in Nevada. And they're not just going to usually give you one to just park in your documents until you need it. I think there needs to be a pretty bad diagnosis, a terminal situation where you, again, that's sort of the pulsed idea kind of factors into the idea of the DNR. But people come in and ask for a DNR, and it's my understanding that in Nevada, we as attorneys can't do that, can't craft that for you.
Maybe, Jim, you can also add to this. This is not specifically the situation with an ambulance coming, but we had a guardianship case recently where even where there's a guardian appointed, there's a situation where the gentleman was in the hospital, he's really ill. They resuscitated him, like let's say on a Thursday night, and Friday morning they called and they said, we need the guardian to say we don't have to keep resuscitating him because his ribs are broken, he's not coming back. You know, they're getting ready to put him on dialysis to keep him alive, to keep, you know, his kidneys functioning. And we still had to go before the judge that day to actually request permission to not resuscitate in that situation. So I just bring it up because it's my understanding that a guardian, even when they're appointed, there's still going to be some oversight of the court in a resuscitation situation.
Great question, Barry. Anyone else have any other questions, comments, discussion points for our panelists? No, I know it's been a long day with a lot of really, really good, oh, there you go, Dr. Amaya.
I have a question, please. In order for all of this, you need to have an attorney who is licensed in Nevada to proceed with this, all this, what you've been talking about today, or there are other people who have the power to help you?
If you're speaking about the durable power of attorney for healthcare, you do not need to have an attorney prepare that. If you're talking about guardianship or court proceedings, I would advise that you have an attorney to do some of those documents. But the document that I spoke of does not require an attorney. It's just a little tangled in the wording, so we do it a lot in our office to kind of help demystify the language a little bit. That no, it's not required. A notary is required, but not an attorney.
And so do you have a contact number?
I
Do you have cards?
You know what? Let me see.
Excuse me, I'm sorry.
There should be a phone number on the booklet.
Okay.
Look on the booklet. I believe it.
Well, can you hear me if I just talk?
But we're recording, if you don't mind.
So I just wanted to add, yes, for some documents you do not need a power of attorney, but for the things that Valerie was talking about putting together a trust and putting together more complex estate planning, yes, you should get an attorney who is licensed in Nevada, because they are practicing in Nevada and they will be familiar with Nevada law.
Okay, thank you.
And I implore you, don't do your own documents. When it comes to wills and trusts and deeds, please don't. The durable power of attorney is one thing, but please don't do your own documents.
Go ahead, sir.
Mel Goldberg. I had heard that for existing guardianships, they might make people reapply under the new law. Is that correct or not?
So when there was the big change in the law, some of the judges were granting guardianships with an expiration date, meaning that you would have to come back before the guardianship expires and basically tell the judge that you needed it to continue. They are not doing that anymore as far as I know, and I have heard nothing about any requirement that old ongoing guardianships would need to reapply. Now, Riley's job is to go through the old guardianships and make that, part of his job, is to go through the old guardianships and make sure that the guardianship cases are in compliance. So ongoing guardianships where the guardian hasn't necessarily done what they're supposed to do, they haven't filed their annual accountings, they haven't filed their annual reports of guardian, they may get a notice in the mail saying, you have to come to court. It's not necessarily about reapplying for guardianship. What it is the judge is saying, I want to know what's going on and why you haven't filed these documents.
Okay, so they're appointing attorneys for the protected person. Are they doing that in all cases? Are they doing that in existing cases? And if they are doing that, can a person have their private attorney?
So anyone is always free to hire their own attorney. So yes, even someone under guardianship, if they would rather work with their own attorney, which is sometimes the case if they have an ongoing relationship, rather than the court-appointed attorney, that is certainly their option.
Well,
right now, attorneys are being appointed in all new guardianship cases. When the cases come up for review every year, oftentimes, especially if the judge sees an issue in the case, the judges are also appointing attorneys in those cases. Now, there are about 3,000 guardianship cases, adult guardianship cases in Clark County. So right now, our office has about 1,000. That means there are 2,000 guardianship cases that are ongoing that do not have attorneys. Eventually, we will have all those cases, but we are not affirmatively going and appearing in cases, especially where there's no issue.
okay, so so the person doesn't have to be proactive. They don't have to go and make a motion to having a private attorney appointed right now?
No.
Okay.
The protected person, if it comes up for review and the protected person wants an attorney, they can certainly ask the judge to appoint an attorney.
Well, the protected person wouldn't understand any of it, so.
Well, the guardian could too. If the guardian wanted to, they could also request
But
it.
the guardian could not act as the attorney, right? Because there'd be a conflict.
Correct. The guardian
Yeah.
cannot act as the attorney.
Okay. Okay, thank you.
Sure.
All really great questions. I would like to have Maria Dent come back up and thank everybody.
I'm now known as Habalong, by the way. Yes, I want to thank the panel. I've worked for AARP for over 15 years, and in my tenure here, I've had the privilege of working with all the offices represented here and worked on the lockbox, and certainly I feel we can do much more to promote the lockbox by the numbers that we saw up there. And personal experience, my parents went through Senior Law Project and did their work through them, and I have a that's my cane. Feel no sympathy for it. And we worked with your Senior Law, and certainly working through the documents from both other agencies have been very critical to us. We work with Barbara Buckley in the Assembly and really help pass laws. So we will continue to do that. Our advocacy work really ties in with this, but so does our outreach work. We can pass all the laws we want, But if folks don't know that these laws exist, they're of no importance to anyone. In the same instance, we have some very important work to do in the state legislature. So we urge you, I know many of you are receiving emails from us, but urge you to bring your families along into passing these laws, because they affect all of us, not just the senior population. You know, we are known to work for the 50 plus, but really our founder, and we're turning 60, you heard earlier from Barry. What we do for one, we do for all. And certainly along this line, it affects all of us, all ages. I have 86-year-old parents, but I'm a widow who I may someday need someone, so I better be thinking about it. Or I may suddenly find out that my name is in the lockbox as a guardian, and God help that person. But we do have a responsibility. We live in neighborhoods that have a lot of folks who've come to this great community, the great state of Nevada, to call it home, and really have no social support systems. So it is important that we are aware of what's out there and how we can build a better community. And certainly by arming ourselves with this knowledge, it is a tough subject. My hat goes off to all of you who are still in the audience, because it is a lot of information we got today. But it is important information that we must know, because I think we get so confused by all the different forms out there, and what's the guardian, and what's the durable power, and what's the living will, and what's the document, and who should house it, and which one trumps each other, and does the doctor have it, does the lawyer, you know, it's overwhelming. And so I want to thank each one of you today for bringing this wonderful information to us, and know that we will continue to ensure that our members and the public know what is out there and what great work we have. I also want to thank the audience. We have both members and community partners that have come here, that I know now you are better armed to take this out into the community. If you would like to see more of this type of presentations done by us, let us know. I have a great staff. Linda put this together in a time when we were working on Get Out the Vote, No on 3, fraud prevention, doing a lot of other stuff, but we were still able to garner this kind of participation, both from panels and audience. So Linda, I want to thank you for your great work, and for the rest of the team who really came up, and we all support each other. Mary, Jacqueline, Scott, Barry, and our team of volunteers. So without all of them, we could not do the work we do. So on behalf of all of us, I want to thank everyone, and this does conclude our program. Thank you.